So let's talk about the due process hearing. The due process hearing is the big thing. Only the parent of a child with a disability or an attorney representing the parent or a school district may request a due process hearing regarding a student with a disability. A due process hearing is a formal proceeding in which evidence is presented to an independent hearing officer to resolve a dispute between the parents of a child with a disability and the school district regarding the identification, evaluation, eligibility, or placement of, or the provision of a free, appropriate public education, FAPE, to a child with a disability. A request for a due process hearing has to be made within 2 years of the date the alleged action forming the basis of the hearing request was known or should have been known. This 2-year limit does not apply if parents were prevented from requesting the hearing because the school district specifically misrepresented that it had resolved the problem, or they withheld pertinent information from the parent that it was required to provide under IDEA, the Individuals with Disabilities Education Act. To request a due process hearing, parents or school districts must submit a signed written request with the required information to the address that we're going to show you on the form. Okay? You have to send a copy of the request to the school system as well. It has to include the requester's name, address, telephone number, the child's name and address if it's different from the child's resident school district, and the school district the child attends, a statement of the reason for the hearing request, including a description of the problem and a statement of facts relating to the problem, and a proposal, if you have one, for a resolution to the problem to the extent that you know. A request for a due process hearing will not be processed unless it contains all of the information that I've listed, and it's on the form. Once a request for a hearing is received, the Louisiana Department of Education will issue an acknowledgement of receipt, and then they're going to forward it to the request to the Division of Administrative Law, an independent state agency that conducts due process hearings for LDE, Louisiana Department of Education. The Division of Administrative Law will assign an administrative law judge, an ALJ, to the case, and he or she will be provided with a copy of the hearing request. Otherwise, the request remains confidential. The ALJ will then coordinate a pre-hearing conference to discuss the hearing process and establish a schedule for activities related to the hearing. The school district is required to convene a resolution meeting within 15 days of receipt of a request for a due process hearing. If the parent in the school district haven't resolved the due process complaint within 30 calendar days of receipt of the request, the due process hearing timeline begins. The 45 calendar day timeline for issuing a final decision begins at the expiration of the 30 calendar day resolution period. The parent in the school district must agree in writing to waive the resolution session or use mediation prior instead of conducting that resolution meeting. If the resolution session is waived, the 45-day hearing timeline begins on the date of the waiver. The parent isn't going to be able, or the school system isn't going to be able to raise issues at the hearing that weren't included in the hearing request unless the other parties agree to allow the addition of new issues. Both parties have the right to be accompanied and advised by legal counsel and by individuals with knowledge and training with respect to the education, to special education or the problems of students with disabilities. It's my experience the school system does bring their attorney. They have the right to present evidence, confront, cross-examine, and compel the attendance of witnesses. They can prohibit the introduction of any evidence at the hearing that wasn't disclosed 5 business days prior to the hearing. They can separate the witnesses so they don't hear each other's testimony, and an interpreter can be provided if needed. The parent also has the right to decide whether the child attends the meeting or not. The parent has the right to have the hearing open or closed to the public, and the parent has the right to obtain a written or electronic verbatim transcript of the proceedings, as well as a written or electronic copy of the ALJ Administrative Law Judge's written decision, including findings of facts, conclusions, and orders, and get that without cost to the parent. Before the hearing, the parent's entitled to a copy of their child's education record, including all tests and reports upon which the school's proposed action is based. In addition, at least 5 business days before the date of the hearing, the parent and the school district must disclose to each other the evaluations each intends to use in the hearing. Copies of all evaluations and recommendations based on those evaluations must be exchanged by that deadline. If the parent or the school district fails to make these disclosures on time, the hearing officer may bar the evidence from the hearing. If the evaluation is underway and hasn't been completed, you have to make sure and tell each other and tell that independent hearing officer, the ALJ. The decision of the hearing officer is made on substantive grounds based on a determination whether the school district provided the child with a free appropriate public education, FAPE. If the request for a hearing includes or is based on an alleged procedural violation, the hearing officer may find that the child did not receive the free appropriate public education only if he or she finds that the procedural violations occurred and that they impeded the child's right to a free appropriate education, significantly impeded the parent's opportunity to participate in the decision-making process regarding the provision of free appropriate public education, or deprived the child of educational benefits. As part of his or her decision and order, the ALJ, the Administrative Law Judge, may order the school district to comply with the procedural requirements. The independent hearing officer must conduct the hearing and mail the parent and school district a written decision within 45 days from the end of the resolution period. The 45-day timeline may be extended if the independent hearing officer grants a request for a specific extension of time from the parent or the school district. The independent hearings officer's decision is final, and the orders must be implemented unless the parent or school district files a civil action in state or federal court of competent jurisdiction within 90 days of receipt of the notification of findings and decisions from the hearing officer. The LDOE, Louisiana Department of Education, is responsible for the costs of conducting the hearing. Each party is responsible for the costs of their participation in the hearing. So if there's witness fees, attorney's fees, costs of copying documents, those things are the responsibility of each party. As part of his or her decision and order, the ALJ, the administrative law judge, may order the school district to comply with procedural requirements. Oh, am I doing that one over again? I think I'm doing that one over again, you guys. Sorry. So let's go to the next poll. I think this is the last one, huh, Wallace? The Louisiana Department of Education. The Louisiana.
I'm looking forward to launch it.
The Louisiana Department of Education is responsible